Welcome to Law Sessions. I am Jennifer Housen. In this session, we will consider the landlord topic of leasehold covenants. Now, leasehold covenants is really an extension of the lease lecture that you would no doubt have already seen. And leasehold covenants will first of all assume that there is a lease in place. And again, in a previous lecture, a session dealing with leases, you would have understood what that was. As it relates to leasehold covenants, what we are considering here are the terms which are agreed in a lease that relate to the parties' obligations in their capacities as landlord and tenant. Leasehold covenants tends to be what persons consider a fairly dry topic, but the fact of the matter is, if you manage to understand the rights and duties on each party, it tends to be a fairly straightforward topic to deal with in an exam, because once you know what the rights and duties of the landlord are and what the rights and duties of the tenants are, then once you're given a problem question, you should be able to go through and work out what is required from each and what the extent of the obligations are on both parties. So what we will start with, of course, is we will look at the rights and duties of the landlord and tenant. Now, every lease will set out the obligations of the landlord and the obligations of the tenant under a lease. Now, the obligations of the parties are known as covenants and conditions. Every lease, no matter how informal it will have a number of provisions which define the obligations of the parties. Indeed, even if it is an oral contract and therefore an oral lease, at the very least you know where the property is located and how much you're going to pay the rent for. So no matter the informality, it does give you some extent of the knowledge of the provisions which define the obligations. Now, why do you need these covenants and conditions? Well, first of all, from the landlord's point of view, in any event, he's handing over to you an asset worth an extraordinary amount of money, and he wants to, of course, make sure that you, the tenant, look after the property during the duration of the lease, mainly because the property will then revert back to him at the end of the lease. So in effect, if you like, and to say this informally, they are lending the land to you, as it were, as the tenant. Now, the obligations of the parties, as I said, are known as covenants and conditions. And a covenant is a promise from one party to the other for the other person's benefit. And a condition may also impose obligations on a tenant, but if these are broken, meaning that if these are breached, the landlord will have a right to terminate the lease. Now, the landlord does not automatically have this right with a covenant because, as I say, the covenants depend on what is set out between the parties. Now, the obligations under a lease pretty much fall under three main headings. The first is a position of the parties in the absence of express provisions. So where there are no express provisions, there may be certain legal provisions, so certain implied provisions that are there. The second is the position under certain covenants, usually found in the lease. So we look at the express covenants. And lastly, the position of the parties under a lease, which contains what is called the usual covenants. So we would look at the implied covenants, the express covenants, and usual covenants. If we take our start then from the position of the parties in the absence of any express provisions, so what does the common law provide for? In many leases, the parties agree the express covenants, which cover all the relevant points. However, if the lease is silent, then implied terms, which are implied at law, will be added in addition to those which are agreed by the parties. We will, of course, consider the position of each party. Let's consider the landlord first. Well, as it relates to the landlord, from his point of view, there's an implied covenant on him for quiet enjoyment towards the tenant. There's an obligation as well that the landlord not derogate from his grant. And there is also an obligation on the landlord as to the fitness and repair in respect of the premises. Now, if we start with the implied covenant for quiet enjoyment, well, this is implied in every lease, and it is not anything at all to do with noise or anything. I mean, quiet enjoyment is not quiet in the acoustic sense. The tenant, rather, will be free from the disturbance caused by the exercise of adverse rights over the property or neighboring land. Quiet simply means that the tenant is able to use the premises uninterrupted from the landlord. Well, what happens if the landlord does not, for example, allow the tenant quiet enjoyment? Well, the tenant will be entitled to damages if his enjoyment is substantially interfered with by the acts of the landlord. Now, just because an act of the landlord is inconvenient will not necessarily mean that it amounts to a breach of the contract. Now, in the case of Markham and Paget in 1908, where the landlord erected an external staircase which was just outside the property, which happened to look into the tenant's property, although it would appear that it infringed upon the tenant's privacy, the court said that this was not a breach of the right to quiet enjoyment. So simply because it was inconvenient will not be sufficient. But when we take a case like Lavender and Betts in 1942, the landlord removed the doors and the windows in order to get the tenant out. The court considered that of course, impacted on quiet enjoyment. It is worth noting, of course, that landlords can not only face civil sanctions, but also criminal sanctions in the way they deal with tenants under Section 1 of the Protection of Eviction Act 1977 in respect of any harassment that they commit against the tenant. The second implied covenant then, of course, is the obligation not to derogate from their grant. And the landlord and those claiming under him must not make the premises substantially less fit for the purpose for which they are let or rented. So in effect, you must not take away with one hand when you give with another. The classic case is the case of Alden and Latimer Clark in 1894. The premises were rented to the tenants subject to a covenant that the building could only be used for running a timber merchant business. The building included a dry woodshed which worked on the basis of a flow of air passing to the building from the neighboring building, which was owned by the landlord. The airflow was blocked and the woodshed couldn't be used properly by the tenant. The court said that this amounted to a breach by the landlord, as he was the one preventing the building from being used for the very purpose that the lease had been granted on. Lastly, there's a third implied obligation of the landlord, which is the obligation as to the fitness for habitation. Now, in general, the landlord gives no implied undertaking that the premises are or will be fit for habitation, nor is he liable to repair them. This rule, though, is subject to certain qualifications. And the qualifications are these. First, if it is let, meaning rented, as a furnished letting, then in such a case, the landlord impliedly undertakes that it will be fit for human habitation. If that is not the case, the tenant may repudiate the tenancy and claim damages for any loss that he has suffered. And in the case of Smoth and Marble, 1843, the property to let was infested with bugs, of course, that impacted on the tenancy. Secondly, where a house is let at a low rent, then we are looking at it being fit for habitation. Now, if a house is let at a rent, it used to be £80 or less in London or £52 or less elsewhere, but it's roughly, if it's let at a very low rent, then there is an implied condition that it is fit for human habitation at the beginning of the tenancy, and an implied obligation that the landlord will keep it in the condition throughout the tenancy. Now, what about the tenant's obligations? What is the position if the landlord and the tenant haven't agreed the promises and obligations of the lease? Well, the tenant has certain obligations. The first is an obligation not to commit waste. The second is that the tenant has a right to take what are called emblements, a nice old-fashioned word. Also, the tenant has a right to estovers, and the tenant cannot remove certain fixtures. Now, if we start with the obligation not to commit waste, the concept of waste is the same as it is when one considers a life estate, and that is that any act that alters the nature of the land, whether it is for better or worse, that is waste. So whether I go into the property, for example, and I put up pictures, and so I have to put nails or hooks, that's waste. Equally, if I knock down an old shed and put up a brand new one, that is also waste, because waste talks about an alteration, be it for better or worse. Now, the liability of the tenant depends upon the nature of his tenancy, and included in this is an obligation to repair, whereby a tenant must keep and deliver up the premises in a tenant-like manner. The tenant then also has a right to take emblements. This is the right of a tenant to enter onto the land after the tenancy has ceased, and be able to reap anything which he has sown on the land, and that is a right of his. A tenant also has a right to estovers. A tenant for a set number of years has the same right to estovers as a tenant for life. And estovers is simply wood which a tenant may take for domestic and other purposes. The last thing, of course, is that a tenant cannot remove certain fixtures. Those were implied covenants on the part of the landlord and the tenants. Of course, those are implied in the absence of express covenants. So what are express covenants? Well, express covenants will be certain covenants which are set out expressly in a lease in relation to the landlord and the tenant's obligations. Now, that may very well be that it is a written express lease, but it can also be an oral express lease. So, for example, even if the parties say, well, the property is 1 Blackacre Drive and the rent is £500 a month, orally, those are express covenants, because the tenant would need to be paying the rent, and as such, it would have been set out expressly. Well, that's the first one. Covenant to pay rent tends to be an express covenant. This is a requirement of the tenant that unless the lease provides otherwise, rent is normally paid in arrears. That is the common law rule. It continues to be payable even if the premises cannot be used. The rent need not be in money, but it could be in kind. So, for example, you rent me your flat for a Mac and a PC, for example. However, the normal situation is for rent to take the form of regular monthly payments. The second type of express covenant, of course, is rent review. Unless otherwise stated, the rent will remain the same throughout the duration of the lease. Now, there can be a clause included where it alters, for example, in line with inflation, or in line with an express rent review clause. The third, of course, is the covenant to pay rates, and other taxes. Now, I know that this may be unusual in some other jurisdictions, but the tenant may be liable to pay these even though they have not been expressed by the landlord. Certainly, in England and Wales, when you consider the council tax, that has to be paid by the tenant. It is important that this is agreed before commencement of the lease, as this could be expensive for the tenant. So, for example, business taxes, services, and water. There's also the covenant against assigning, underletting, or parting with possession. The landlord, for example, may wish to and has the right to restrict the tenant's ability to sell, of course, dispose, assign, or sublet the property. Now, such covenants come in two forms. The absolute covenant, which means the tenant cannot assign on any basis, and the qualified covenant, which means the landlord's prior written consent will be required. Now, in the case of international drilling, it says that the landlords, under a qualified covenant, the landlord's consent will not be unreasonably withheld. But what if the lease says nothing? We will take a short break and we will continue with the type of covenants that appear in a lease, and certainly we will pick up from this point.